Hello everyone, welcome to Mastermind. This is part 6 of Indian Constitution which we were discussing, and in this we'll start with the part 3. So there has already been 5 videos which has been made, and this is the 6th video. So part 3 of Indian Constitution speaks about what? It speaks about fundamental rights. This itself has been asked a lot of times in the examination. That is, fundamental rights has been mentioned in which part of the Constitution? It is mentioned in part 3 of the Constitution. Now, this chapter itself, that is the fundamental right itself, is also known as Magna Carta of India. So which part is called as Magna Carta of India? It is fundamental rights, or part 3 you can call it as Magna Carta of India. So if you are looking at fundamental rights, it mentions various rights from Article 12 to Article 35. And we have to understand each of these articles, and this is very important because there is no exam in which they have usually missed to ask question from fundamental rights. So fundamental rights, President of India, fundamental duties, directive principles of state policy, governor, Supreme Court, these are some of the important chapters when we are considering Indian polity. In that, if you are looking at the most important chapter, then it is fundamental rights itself. So this chapter itself is also known as Magna Carta of India. Why? Because Magna Carta was more than just a document. That Magna Carta, which was the document previously, it was by whom? It was by King John. It was by King John. So it was not just the document, it was more than the document. That is, individual rights it was related to. Okay, so in that way, this part, that is part 3 of Indian Constitution, relates to the rights of the citizens. So in the previous parts when we were discussing, we saw that we took a territory, we named it as India, and we said how people will be there, or who will be the citizen there. So in the previous part we have seen who can be the citizens there. Now you have got a country, you have given the citizenship, you have defined who can be citizen there. Now what rights do they have? Correct? What rights do they have? That also you have to mention, right? And hence that is mentioned in the part 3 of Indian Constitution. Let us start with this particular part by starting to understand Article 12. Article 12. See, Article 12 is not speaking about any right. That is why they have mentioned in the Constitution as its general. Under fundamental rights, under general section, it is Article 12. Article 12 says what is a state. Article 12 says what is a state. Now, why does it have to say or define what exactly is state? Correct? Why it has to tell what is the state, or why it should define what is a state? Because most of these rights, almost 60 to 70 percentage of what we are reading in this fundamental rights, most of it will relate it with respect to state only. That is, the state shall not take off any rights, the state shall make sure, etc. So we have to exactly know what is the state. Is parliament the state? Is parliament the state? Yes, we can call parliament a state. Then what about state legislature then? What about state legislature? Okay. What about the state legislature of different states? That is, one state legislature, okay, we can consider it to be the state. The state of the legislatures of other states, those also you can consider it as state. Yes, those also you can consider it as state. So it will be very difficult in the Constitution to mention Government of India, Parliament, state legislatures, local bodies, etc. Every time it mentions about any rights, it has to mention about all of these things. It will be very difficult, and hence instead of all of these, they are mentioning it as state. They are mentioning it as state. Now what state includes? The state includes government and Parliament of India. So it includes government of India also and Parliament of India also. Then it includes the government and legislature of each states. Okay, it is mentioning government and Parliament of India, government and legislature of each state, and also local bodies and other authorities within the territory of India, or which is under the control of government of India, is considered as state. Now imagine how difficult it would be to mention what exactly is a state when we are reading about every individual article. It would be very cumbersome, right? And hence they have defined it in Article 12 itself. Okay, so now what constitutes the state? Government of India. Government of India constitutes the states? Yes. Parliament of India, it constitutes the states? Yes. Government of states, that is government of Karnataka, government of Maharashtra, that constitutes the state? Yes, it constitutes the state. Legislature of the states, that also constitutes the states. Local bodies, that also constitutes the states. And if there are any other authorities which is under control of government of India, that is also part of the state only. That is also part of the state only. That is, these organizations, any of these violates any of the fundamental rights, then it goes against the part 3. That is, nobody who have been mentioned over here has to be withdrawing any rights. But along with the rights, there are a lot of exceptions also. So while we are discussing the articles, we'll discuss about those as well. But till here, I hope what Article 12 is very clear to you. We are taking lot of time to discuss every individual article. Each of the article we are trying to understand it in a little more detail. That is why we are going very, very slow. But once you understand all of these articles, then it will be easier for you to just revise those articles as you go. So Magna Carta of India, this is part 3, that is fundamental rights. The actual Magna Carta was by King John. Then Article 12 gives the definition for the state. Let us move on to next article, which is Article 13. Now we have defined what exactly is state in Article 12. Article 13 says that if any law is made, or if any regulation is made by the state which is inconsistent or which affects fundamental rights, then automatically that law becomes invalid. I hope you are able to understand. Now let's say there is a state of, let's say Telangana. Let's say example, state of Telangana has come up with a law which, let's say, affects right to which right do we take? Let's take right to equality. Example, right to equality or right to privacy. If the state has made a law which affects the right to equality or right to this privacy or any other rights, that is right to education, etc., automatically that law becomes inconsistent. That is what the article is trying to tell over here. Let us read the article as it is. The laws which are inconsistent with or in derogation of the fundamental rights, in that they have given different sections over here. There are different clauses over here. Clause 1, 2, 3, and in that, and the last one is 4. Let us see what each of it is telling. First one, it is telling all laws in force in the territory of India immediately before the commencement of the constitution. Commencement of the constitution and related to citizenship we have seen in which? Article 5. Article 5. So all the laws in force in the territory of India immediately before the commencement of this constitution, in so far as they are inconsistent with the provisions of this part in the sense part 3, if the laws which has been made before the constitution came into place, and if that law is not inconsistent, if it is taking off any of the part of fundamental rights, or if it is inconsistent with the provisions of fundamental rights, then it would be considered as void. That is, it is invalid. So the first part it is telling, in the first clause it is telling, before constitution, the laws in place, and against part 3 is void or invalid. So that has been mentioned over here. So if there is any law which has been made before the commencement of the constitution and that law is inconsistent with that of fundamental rights, it is considered as void. I hope till here it is clear. Now let's say what is second clause saying. The state shall not make any law which takes away or abridges the rights conferred by this part. Whenever it is saying this part, it means part 3. It means part 3 which speaks about fundamental right. So if the state, see here they are mentioning about what? Here they are mentioning about state. The definition of the state itself we have seen in article 12, correct? So if this state has made any law which takes away fundamental rights, then that is also considered as void. That is what the subclause 2 is telling. 13 subclause 2, it is telling the same thing. The state shall not make any laws which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall to the extent of contravention be void. So in other words, it is telling that if state makes any laws which takes away fundamental rights, then it is invalid. I hope till here it is clear. Now let us see the third clause, that is article 13 subclause 3. In this article, unless the context otherwise requires, there are two important conditions. When they are mentioning about the law, what is the law actually? We have mentioned what is state already. We have already mentioned what is state. What includes state also we have mentioned. Now let us say there is something which we have mentioned over here which says that law. Okay, so here also we have mentioned it as law. Now what exactly is law? If the state or the part of the state makes, is it law? Or if some rules has come, that is also considered as law. What if there is ordinance in place? Is that considered as a law or not? So that confusion might arise, right? And because of that only, this makes it very clear. It defines or it gives the context for law. What exactly is law is mentioned over here. Law, it includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage which is having in the territory of India the force of law. So law includes all of these. So any of these are taking fundamental rights away, that is to be considered as invalid. Now what do you mean by laws which is in force? It means the laws which is passed or made by the legislature or competent authority within the territory of India before the commencement of this constitution and not previously repealed. That is law which is in force. We have seen over here, right? Law which is in force before the constitution came into place, and that law we have not taken down. Okay, that law which is in force before the commencement of the constitution itself, and that law which has not been repealed, notwithstanding any such law or any part thereof may not be then in operation either at all or in particular areas. That is what they are mentioning. Law in the force also they are giving proper explanation for. Next, the last one, 4. So 13 subclause 4. Nothing in this article shall apply to any amendment of this constitution made under article 368. Now what is it trying to tell? Nothing in this article shall apply to any amendment of this constitution made under article 368. So we know that under article 368 we can make changes to the constitution. We can amend the constitution, that is called as amendment, correct? So if there is amendment, that at that point of a time this will not apply. That is, any of the amendment which is made in article 368 of Indian constitution that cannot be challenged under article 13. Under article 13 it cannot be challenged. Moreover, what happens is if the amendment so made would be against the fundamental right also, then also it would not be challenged under Article 13. That is, Article 13 here in this case mentions about legislative law. It mentions about legislative law. It is not mentioning about constitutional law or constituent law. Okay, that is, constitution law means the law which is made to amend the constitution. It is to amend the constitution, whereas in this case we are mentioning it is about law, right? So this means it is legislative law, the law which has been made by the legislature. So that they are mentioning it over here. That means that amendment, if it is made against fundamental right also, then also it cannot be challenged under Article 13 is what they are pointing out over here. And this itself had given, that is the Article 13's reference itself had given birth to the landmark doctrine, which is basic structure doctrine. That is, there are some provisions which cannot be changed, whenever you are looking at the amendment also. That we'll discuss further, but for now you just understand that there is legislative law and then there is constituent law. That is 13, when we are speaking that it cannot be the laws which are inconsistent and which is in derogation, etc. When we are mentioning it like that, we are mentioning it as legislative law, we are not mentioning it as constituent law. So this type of clarity is also important for us, because it will be helpful to answer the questions if they are not asked directly at point in the examination. So in the next part we'll discuss a few more articles.